Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to continue our deep dive into the case of Richard Sr. Now, if you haven't been following this, you might be a little lost. I did a couple of videos talking about the facts of this case, which are wild. I'll try to do a really brief rundown here. So, Constable Sr. is a police officer. He's been found guilty of a number of corruption-related offenses. We're going to look and see, how does that happen? So this starts out with, essentially, they think he's misusing certain police databases, and to investigate that, they really go and start digging into his life. They wire up his cell phone as a monitoring device, so his cell phone is essentially wiretapped and bugged. They bug his car, they bug his patrol car, so both his personal vehicle and his patrol vehicle, it seems like. Also, his partner is actually an undercover cop who is investigating him. Constable Sr. also thinks he's got a great confidential informant, and he thinks this is a mid to high level organized crime figure, but actually this figure is another undercover police officer. That sort of confidential informant, who is, again, really another police officer, keeps feeding him information that Constable Sr. gets told has led to these big busts that are going to be great for his career. You know, we seized all of this, drugs, money, firearms, all of this stuff. So pretty much everything that's been going on in Constable Sr.'s life is organized and monitored at this point because they're investigating whether or not he looked up stuff in databases that maybe he shouldn't have looked up. You might be thinking, well, that seems like a really in-depth thing for something that seems a little more minor. However, it starts out with they can't really get him initially to do anything. They're asking him, oh, can you get me some steroids? And he says, no, I can't do that because, you should instead just, work out more, eat more protein, healthy living. So that's how it starts. How it ends is Constable Sr. and his partner, who, again, undercover cop, stealing a shotgun from the police, loading it up along with a kit, which is essentially, for going on a robbery. They're going to rob and rip off people who they think are drug dealers. Of course, those drug dealers don't exist. And at the point where they go as far as getting the shotgun and, the masks and all of that, they get arrested. So that's where we are here. The court, having sort of gone through all of the facts from the beginning to the arrest, is now going to go through the analysis. And so we'll go through that together. I'll explain a little bit about what's going on as we go through it, because often these analyses are written for other judges and other lawyers, and not so much the public. All right, so they're going to start out, we see presumption of innocence / burden and standard of proof. This is very common in decisions where they start out by reviewing essentially the starting point. And so the starting point is that you are presumed to be innocent. They say, as with anyone facing a criminal charge, Constable Richard Sr. is presumed to be innocent of all charges faced. So until it's proven otherwise, you're innocent. Section 11D of the Charter states, any person charged with an offense has the right to be presumed innocent until proven guilty according to law in a fair and public hearing by an independent and impartial tribunal. So that's your right to both. There's a whole bunch of rights actually packed in there. Right to be presumed innocent until proven guilty, fair and public hearing, there's no sort of secret trials that'll convict you, and independent and impartial, also important. The Crown has the burden of proving the essential elements of any offense beyond reasonable doubt. If the Crown fails to fulfill this burden on any essential element of an offense, Constable Sr. must be found not guilty. Now you might be saying, what the heck is an essential element of the offense? Because that's a little weird. When you have a criminal offense, it'll say what the crime actually is, what the offense is. And we can break that down a little further into different pieces. Each of those pieces has to be proven. So those are the essential elements of the offense. We'll see some examples as we go, and I'll be able to explain that a little further. A reasonable doubt is based on reason and common sense. It is based on the evidence or its absence. The absence of evidence is also a big thing here, right? There's plenty of times where there's just a hole in the Crown's case where something could have happened, but maybe could have not happened. So a gap in the evidence can also found a reasonable doubt. Constable Sr. was not required to and did not testify at this trial. This is a very important thing. You are not required to testify at any trial where you're on the hook, basically. If you're the accused, you're not required to testify. And the court actually cannot draw an adverse inference. They can't say that because you didn't testify, you're more likely to be guilty. Juries are also cautioned that people have the right not to testify, and that this doesn't mean that they're guilty, or it doesn't mean that they're innocent. It just means nothing, right? You have that right. Juries, on the other hand, may have their own opinions sometimes, so this can be risky with a jury. As much as you tell juries, here's how we want you to make the decision, sometimes juries have their own ideas. They say, this, however, does not alleviate the need for the court to consider the principles underlying the WD instruction in this case. WD is quite possibly the most important criminal case of all time. It's cited so often. And so WD basically sets out a three-part kind of analysis. So the first is, if you believe the accused, when the accused has testified and offered evidence to their own, that would clear them. So if you believe the accused and their defense, then you obviously have to acquit. But if you don't believe the accused, you might still have some reasonable doubt as a result of what they said. The accused might have given you a story and you're like, I don't believe this guy, but it's possible, so I have to acquit as well. And even if you don't fall into those two categories, maybe the accused testified and you just think it's such ridiculous utter lies that it's completely useless, the Crown still might not have proven its case. So that's the third part, is did the Crown prove its case beyond a reasonable doubt, even if the accused's defense is useless? Now, this is not my favorite way of phrasing this issue, but it's the way the courts usually go with. So continuing on here, they say the WD instruction arose in a case where the accused testified. This was manifest in the actual language of the famous tripartite formulation of the instruction, which refers explicitly to the testimony of the accused. So the tripartite formulation is what I just went through. It's got three parts. Language in that case is a little unnecessarily dense, but that's courts for you. However, subsequent case law has made it clear that the principles underlying WD are not confined merely to cases where an accused testifies and their evidence conflicts with that of the Crown witnesses. This is expressed by Blair in Queen and BD, where, on a vital issue, there are credibility findings to be made between conflicting evidence called by the defense or arising out of evidence favorable to the defense in the Crown's case. The trial judge must relate the concept of reasonable doubt to those credibility findings. So this is saying that WD applies not just to, testimony by the accused, but also to any evidence that applies in favor of the accused, whether that was called by the accused or whether that's things in the Crown's case where Crown witnesses might have said something where you're like, that's helpful, that acquits my client. In the present case, there's a great deal of evidence emanating from Constable Senior, given the various intercepted communications, because they were wiretapping him all the time, and they tendered literally thousands of pages of agreed statement of facts here. So we've got a ton of things Constable Senior said. It is essential that this court consider this evidence when assessing whether the Crown has proven any of the offenses beyond a reasonable doubt. So entrapment. This court agrees with the Crown that much of the cross-examination of the witnesses at this trial was not relevant to guilt or innocence, but rather to a potential entrapment application. So you might be saying, well, what does this mean? Well, entrapment is kind of its own special thing. Entrapment isn't saying, listen, I'm innocent because I was entrapped. It actually is that the court has to find you guilty first, and then you make the entrapment argument. And the entrapment argument is a second step, which basically says, notwithstanding the fact that we've found you guilty, because of entrapment, we should throw everything out. Now, the entrapment element hasn't happened yet, but clearly the defense is going to want to get some of that evidence out at cross-examination at this stage, right? So the court, or the Crown and the court, are basically saying a lot of what we heard was for a future proceeding, not for determining guilt or innocence. So this court must not consider this evidence at this stage in determining whether the Crown has proven any offenses beyond a reasonable doubt. In the Queen and Amoro, the Crown appealed an acquittal. Prior to determining guilt, the trial judge had ruled that the investigating officer's conduct amounted to entrapment, excluded the seized drugs and money from evidence, and acquitted. The Court of Appeal held, the trial judge held that as she was sitting without a jury, she could consider whether the undercover officer's conduct amounted to entrapment at the outset of the trial before determining whether Mr. Amaro was guilty. This holding, respectfully, is contrary to Mack and to the Supreme Court of Canada's later decision in the Queen and Pearson. In Mack, Justice Lemur stated at 972, before a judge considers whether a stay of proceedings lies because of entrapment, it must be absolutely clear that the Crown has discharged its burden of proving beyond reasonable doubt that the accused had committed all of the essential elements of the offense. Although in Mack the accused was tried by a jury, I do not read Lemur's statement as being limited to jury trials. In the very next sentence, on page 972, he added, if this is not clear and there is a jury, the guilt or innocence of the accused must be determined apart from the evidence which is relevant only to the issue of entrapment. Why should guilt or innocence be determined before a judge considers entrapment? Lemur provides the answer. This protects the rights of an accused to an acquittal where the circumstances so warrant. All right, that's really dense, right? So let's break this down. They're saying, as I mentioned before, 2-stage trials here. So stage 1, did you do it? Are you guilty? Stage 2, if you are guilty, because of course, if you're acquitted at stage 1, you don't need stage 2. We can just skip that. But stage 2 is if you are guilty, should we still allow that to stand as a conviction? Because of this entrapment. Is the entrapment such that it should throw out the finding of guilt? So that's sort of what's going on here. But what they're saying, the court is saying here, is that this first step is an essential protection for the accused, because that acquittal is better in some ways than the finding of guilt with entrapment. Think about how that looks to, future people looking at this. So if you have an acquittal and that acquittal is possible, they shouldn't find entrapment and thus not find the acquittal. They should acquit you first and then skip the entrapment step. So the court is saying it's very important that these be kept separate. They're different issues. They need to be considered separately. All right, moving on. In Pearson, Lemur and Major, writing for the majority, noted that entrapment is not a conventional defense. It puts in issue not the accused's culpability, but the conduct of the state. Thus, as the majority notes at paragraph 15, it arises after a fair trial has found the accused guilty. Accordingly, a claim of entrapment leads to a 2-stage trial. At the first stage, the trier of fact determines whether the accused is guilty. If the accused is found guilty, the trial moves to the second stage, where the judge considers the claim of entrapment. In setting out these 2 stages, the Supreme Court did not distinguish between jury and non-jury trials. Whatever the mode of trial, the judge ought to consider entrapment only after a finding of guilt. This bit about the conduct of the state is very important here, because an entrapment defense doesn't say, I'm not guilty. It says, I did it. However, the reason why I did it is because the state, the government, the police made me do it. They put me into a situation where, my will, where it was sort of a forced issue, where they pressured me into it. And so essentially the entrapment defense is saying, the state conduct is so bad here that we need to throw out this guilty finding and let somebody walk free. Notwithstanding the fact that they did a bad thing, the state is on the hook here. The state has acted so badly that this has to be thrown out. In some ways, we can consider this similar to a charter argument, where the charter argument might be, listen, we know you found drugs. However, the way you found those drugs violated the law and my rights, and therefore those drugs cannot be fairly used as evidence. There's a similarity there, at least to my mind. Court's now going to spend some time talking about circumstantial evidence and the special rules that the court sort of follows around circumstantial evidence. Now you might be saying, what is circumstantial evidence? Lots of us have heard this term, but may not have heard a proper explanation. Well, the real short explanation is that circumstantial evidence is any evidence that is not direct evidence. Now, I can hear you saying, Runkle, that's super unhelpful. What is direct evidence then? Well, direct evidence shows directly that somebody committed the offense. Let's consider an example. So a bank gets robbed, and we have a witness, perhaps the teller, who says, Joe walks in, he's not wearing a mask, he walks directly up to my teller station, He pulls a gun out of his jacket, shows it to me, says, I have a gun, give me the money or I'll shoot you. The teller says, I went and got some money, I gave it to Joe. Joe took the money, Joe put the gun back in his jacket, Joe left with the money. That's direct evidence. The teller is saying, I saw Joe doing the crime right at that time. So that's an example of direct evidence. It's showing directly that Joe committed the offense. But let's consider a circumstantial case for the same crime. So a bank has been robbed, and this has been on the news. Everybody knows that the local bank has been robbed because small town. So Joe's girlfriend calls the police and says, I think Joe robbed the bank. Police say, cool, that's great. Why do you think Joe robbed the bank? She says, we've been fighting about money. He doesn't have any money because he's out of work. He just sits around smoking meth. He is useless. And suddenly he comes home and he's got a whole big wad of cash. And he says, our problems are solved. I've got all of this money. And she says, where did you get the money? And he doesn't answer the question. He refuses to answer the question. And so she's suspicious. So she digs around through his stuff. And she finds that he's got a mask and a gun and maybe a note that says, give me the money or I'll shoot you. And she looks at his jacket, and it turns out his jacket matches the jacket that was worn by the robber. This is a pretty good reason to believe Joe might have committed this offense, but it's a circumstantial case. It's not Joe did it. It's Joe is now in possession of all of these things, suggests he's the robber. So that's a circumstantial case. It's based on a whole bunch of pieces of circumstantial evidence. So hopefully that kind of illustrates the difference here. The court says the defense submitted that the evidence as to Constable Senior's intent in relation to the counts before the court is almost entirely circumstantial. And that's almost always going to be the case with respect to intent. Intent is usually established through circumstances. In Villeroman, the Supreme Court of Canada described the relationship between circumstantial evidence and proof beyond a reasonable doubt. The court stated in part as follows. They're talking about what the test is for how do you get to proof beyond a reasonable doubt on circumstantial evidence. Lots of people say, well, you can't. You know, they can't convict me. The evidence is all circumstantial. Well, sometimes circumstantial evidence can be overwhelming. Circumstantial evidence can in some cases be far more compelling than direct evidence. Let's think of an example here. So let's say your house gets broken into and your neighbor says, I saw who did it. I saw it as it was happening. It was Bob. I know Bob and I saw him break into your house. Open and shut case, right? Well, maybe not. What happens if this is a rural property and the neighbor is 300 meters away when he says he sees this? What if he's 87 years old and has terrible eyesight and couldn't find his glasses that day? What if it's also foggy and at night? Now we're thinking that maybe the neighbor's assessment that it's Bob is not super reliable because there's all sorts of ways he could be wrong about that. But let's consider some circumstantial evidence. Let's say that in the course of the break and enter, a window is broken. And there's evidence that there's blood that's found on that broken glass, suggesting somebody cut themselves either breaking the window or climbing through it. And they run that blood through their DNA analysis, and it comes back to a match, somebody who's already in their system. And that's Fred. So they go over and they get a warrant for Fred's house, and they find Fred there. And Fred has cuts on his arm and his stomach from what appears to be climbing through a broken glass window. They also find property there that belongs clearly to you. You know, this is uniquely identifiable property. It is your property. Are we thinking we've got a really good case against Bob? Or are we thinking we got a really good case against Fred? I don't think there's a prosecutor in the land who would say, we're going after Bob instead of Fred. Fred is clearly the guy. But the case against Fred is purely circumstantial evidence. It's still far stronger than the case against Bob. So circumstantial evidence, people say, oh, well, it's not such a, you know, nobody can get convicted on circumstantial evidence. Fred certainly could. Anyway, let's carry on here. The court has generally described the rule in Hodges' case as an elaboration of the reasonable doubt standard. Now, if you're thinking this judgment is going to explain the rule in Hodges' case, it's not. That's again because these tend to be written for lawyers and judges, but we don't always communicate the best with the public. What the rule in Hodges' case says is that if we have a circumstantial case, The case must be consistent with conviction, because obviously, otherwise, how can you convict if it's not consistent with conviction? But also not consistent with any other sort of rational explanation that would lead you to not conviction. So I'll give an example here to explain that better a little further. They say, if that is all that Hodge's case was concerned with, then any special instruction relating to circumstantial evidence could be seen as an unnecessary and potentially confusing addition to the reasonable doubt instruction. However, that is not all Hodge's case was concerned with. There is a special concern inherent in the inferential reasoning from circumstantial evidence. The concern is that the jury may unconsciously fill in the blanks or bridge gaps in the evidence to support the inference that the Crown invites it to draw. Baron Alderson referred to this risk in Hodge's case. He noted the jury may look for and often slightly distort the facts to make them fit the inference that they are invited to draw. Or, as his remarks are recorded in another report, the danger is that the mind may take a pleasure in adapting circumstances to one another, and even straining them a little, if need be, to force them to form parts of one connected whole. While this 19th century language is not suitable for a contemporary jury instruction, the basic concern that Baron Alderson described, the danger of jumping to unwarranted conclusions in circumstantial cases, remains real. When the concern about circumstantial evidence is understood in this way, an instruction concerning the use of circumstantial evidence and the reasonable doubt instruction have different, although related, purposes. And they cite to an article here. Now, what they're talking about here is that when we have a whole bunch of kind of disconnected facts, we tend to want to assemble them into a coherent story. So I'll tell you a story here just as an example. Let's say somebody's car is stolen, and a week later that car is found abandoned in the woods, and the police search the car because they're trying to figure out who stole it. In the course of that search, they find a cigarette butt in the ashtray, and there's only one, which is a little weird, because if you're a smoker, usually you probably have several, not just one. So they call up the owner and they say, hey, do you smoke? Or does anyone you ride with smoke? And they say, I don't smoke. I don't let anyone smoke in my car. Nobody smokes in my car. So the police say, okay, this cigarette butt is a clue. They take that cigarette butt and they run DNA, and it comes back to somebody who is a known car thief, prolific car thief, dozens of convictions. And they say, great, we've got our guy. And so they go and charge that car thief. But they ask that car thief to make a statement, and being smart, he says, no, not doing that. So the evidence they've got is this car was stolen. A week later, it's found in sort of an abandoned location, and they've got his DNA that was sort of on site. And it's really tempting to say, yes, this makes sense. The guy steals the car, he smokes a cigarette, ashes it out in there, we find it, problem solved. The problem is that there are other possible conclusions if you start to sort of break things down. A week is a fairly long period of time. Maybe somebody steals the car and picks up a hitchhiker. And it could be that this hitchhiker happens to be a prolific car thief, but he may not have been involved in the theft of this particular vehicle. And that hitchhiker might have said, hey man, do you mind if I smoke? And car thief says, I don't care, because it's not his car. Not worried about it. So hitchhiker smokes a cigarette, ashes it out in the ashtray. Hitchhiker may not have known a single thing. Now you might say, well, how likely is that? Well, it may not be super likely, but it is super possible. And that's enough to raise a reasonable doubt here. So just the fact that you have DNA evidence doesn't necessarily tell you where the case is circumstantial, as here, that you're going to get a conviction. So that's kind of what this is getting at, is that sometimes it can be dangerous if you assemble all of these facts into a sort of coherent account, especially where people start, as they say, trying to wedge facts in that don't really fit, because, where a fact sort of sticks out and it doesn't really fit with the rest of the narrative, often people will say, well, here's a way to make it fit. When what they should be saying is, maybe this whole narrative has a problem. Maybe something else is going on. So that's really what this caution is about. That's sort of what this warning is about. The reasonable doubt instruction describes a state of mind, the degree of persuasion that entitles and requires a juror to find an accused guilty. Reasonable doubt is not an inference or a finding of fact that needs support in the evidence presented at trial. A reasonable doubt is a doubt based on reason and common sense. It is not imaginary or frivolous. It does not involve proof to an absolute certainty. and it is logically connected to the evidence or absence of evidence. The reasonable doubt instructions are all directed to describing for the jurors how sure they must be of guilt in order to convict. The evidence or absence of evidence is a really important point, because the accused doesn't bear any burden in terms of establishing that they are innocent. The Crown has to prove that they are guilty. So gaps in the evidence can be a big deal, right? Gaps in the evidence can say, well, that's a fatal flaw here. It follows that in a case in which proof of one or more elements of the offense depends exclusively or largely on circumstantial evidence, it will generally be helpful to the jury to be cautioned about too readily drawing inferences of guilt. No particular language is required. Telling the jury that an inference of guilt drawn from circumstantial evidence should be the only reasonable inference that such evidence permits will often be a succinct and accurate way of helping the jury to guard against the risk of filling in the blanks by too quickly overlooking reasonable alternative inferences. It may be helpful to illustrate the concern about jumping to conclusions with an example. If we look out the window, and I love examples. Examples are a great way to really assess all sorts of legal issues. Thinking of hypotheticals, thinking of, what-if scenarios. They're a great way to understand things better. So I love examples. I always like when the court sort of gives this, because it makes it much more accessible to especially the ordinary person. So if we look out the window and see that the road is wet, we may jump to the conclusion that it has been raining. But we may then notice that the sidewalks are dry, or that there is a loud noise coming from the distance that could be street cleaning equipment, and reevaluate our premature conclusion. The observation that the road is wet on its own does not exclude other reasonable explanations than that it has been raining. The inferences that may be drawn from this observation must be considered in light of all of the evidence and the absence of evidence, assessed logically and in light of human experience and common sense. So I like that example. It's a very sort of clear, consistent example that tells us, sometimes our immediate conclusions can be wrong, and we have to consider that when we're deciding whether or not somebody is guilty of a criminal offense. In Darnley, the Court of Appeal for Ontario provided some further clarification. Moreover, an inference need not arise from proven facts, which is a standard that is never applicable to an accused. The accused doesn't have to prove anything to establish reasonable doubt, except in certain scenarios where there's some sort of positive defense. They may have to establish that to a certain low standard. I'm not going to get into those details, but so they say this is because a reference to proven facts suggests an obligation to establish those facts to a standard of proof. Yet a reasonable doubt can arise from evidence that, while not proven to be true to any standard of proof, has not been rejected. Let's think back to our burglar, where the neighbor says, hey, it's Bob that did it. We can't say that we've proven that the neighbor is wrong about Bob, but we can say that because of those weather factors, it's distant, the neighbor's eyesight is bad, the fog and so forth, we can say that the fact or the notion that it is somebody other than Bob has not been rejected because his evidence is not very good. So it is also incorrect to link a reasonable doubt to a conclusion drawn from the facts. An acquittal need not be based on a conclusion about innocence, but can rest on an inability to conclude guilt. Again, if we think of our burglar, I can't say that the neighbor is wrong necessarily, but I can't say that the neighbor is right either. So we can be in a situation where you're unable to make conclusions, and that situation always operates to the benefit of the accused. It is also an error to suggest that an exculpatory inference must be a much stronger conclusion than a speculation or guess. That language imports the need for a strong inference, when an exculpatory inference relating to a required element of the offense need merely raise a reasonable doubt. So exculpatory means tending to acquit, so tending to say that you didn't do it. And so it doesn't need to be more than potential speculation, so long as that speculation is within the realm of reasonable doubt. If your notion is, hey, listen, I didn't kill that person because it turns out a unicorn did it, and using its magical unicorn powers, framed me and put my DNA there, which it did magically. And so, that's not going to be a reasonable doubt. But if there's something where you say, simply the possibility of maybe somebody else could have done it, that might be enough, depending on what the evidence is. So the Ontario Court of Appeal, in the case of the Queen and JC, recently stated that judges must avoid speculative reasoning that invokes common sense assumptions that are not grounded in the evidence or appropriately supported by judicial notice. This court has kept these principles firmly in mind in assessing the evidence and in reaching its conclusions. Common sense is super dangerous in the courtroom because lots of times people think they are exercising common sense, and what they're actually doing is stepping outside the boundaries of their knowledge and the boundaries of evidence. This is something I see all the time in gun files. Judges may have common sense notions of how firearms operate and how, various things, elements of the firearms community, these sorts of things. And they might be dead wrong. Lots of people get their common sense knowledge of how firearms operate from the movies, and I will tell you, the movies bear very little relation in terms of accuracy for firearms to the truth. So, yeah, lots of people have common sense inferences that are just way wrong when you actually get down to it. So they say, don't use your common sense because it's probably actually just getting you into trouble. At least not for these assumptions. So, theft of confidential source payments and forged forms. Count 1, theft under $5,000, and count 3, utter forged document. So these are some of the charges for which Constable Senior is in court. Constable Senior is alleged to have kept money that he was given to pay confidential sources, namely Henry Wong, posing as a confidential human source, consisting of 2 payments of $1,000 each, and David Broadhead, the source name he placed on an intelligence report related to Sherry Wafer and family, consisting of 1 payment of $300. The total amount of the theft is therefore alleged to be $2,300. Further, Constable Senior is alleged to have uttered a forged document in submitting payment receipts signed by Henry in circumstances where Constable Senior kept the money, and in submitting a payment receipt forged by his friend Fabian Wills by having Mr. Wills place David Broadhead's signature on the form to indicate Mr. Broadhead had received payment for the information. So the law in relation to theft. In order to find Constable Senior guilty of theft under $5,000, this court must be satisfied of the following essential elements beyond a reasonable doubt. So this is breaking down the offense into its essential elements. Remember, we were talking about essential elements earlier. Now we're going to get to see that sort of in action. So that Constable Senior converted something, that being property, to his own use that belonged to another. B, that Constable Senior converted another's property fraudulently and without color of right. And C, that when Constable Senior converted another's property to his own use, he meant to deprive another, at least temporarily, of the property or another's interest in it. So those are sort of the essential elements of the offense, and now they're going to apply the facts that we went through earlier to these to this test. In this context, take means to get something that belongs to another person for yourself, to transfer it to yourself from someone else. You might say, well, everyone knows what taking is. The law is full of places where we say, well, everyone knows what this means, and it turns out it's actually more complicated than that. So to convert something means to wrongfully deal with it in a way that is inconsistent with the rights of the true owner. As an example of this, if you're at the supermarket and they're selling, sandwiches, and you walk up and you eat the sandwich, that is conversion. You've consumed the sandwich. It is no longer, something that the true owner can deal with in the way they would like, which is selling it to somebody. Person takes or converts property fraudulently and without color of right if they take or convert the property intentionally, knowing that it was the property of another person, and knowing that they were not legally entitled to take or convert the property. The taking or converting is not done fraudulently and without color of right if the person taking it did not know that he was not legally entitled to take or convert the property. Even if mistaken as to his entitlement, the person must be found not guilty. In the Queen and Hemmerly, the defense advanced at trial was that the accused lacked the necessary intent since he believed that he was entitled to the money and therefore acting under a color of right. The court stated, the first ground of appeal is that the learned trial judge erred in law in instructing the jury that the appellant must hold an honest belief that he could collect the debt in the manner in which he did in order to constitute a defense to the charge of robbery. It is axiomatic that a person cannot be convicted of any crime of which theft is a constituent element if he lacked the mental element requisite for theft. In order to constitute theft, the taking or converting of the property of another must be fraudulent and without color of right. The case which is, perhaps, referred to most frequently with reference to the mental element required in theft is the Queen and Bernard. It is thus clear that while the test is subjective in that it is the accused's belief that he has a lawful claim rather than the existence in fact of a lawful claim which determines whether there is a color of right, the accused must nonetheless genuinely believe that he has a lawful claim. Queen and Bernard, which was quoted in approval in the Queen and Housen. The courts have struggled with the meaning of fraudulently in the context of theft and what therefore is required. In the Queen and Brace, Robertson for the court stated, "I shall not attempt to give an exhaustive definition of the word fraudulently, and I say only the words that I'm about to use will fit this particular case. And what I say, adapting the language used by Lord Goddard in the Queen and Williams above, is that fraudulently means that the obtaining of a telecommunication service must be intentional and deliberate, that is to say, without mistake, and with knowledge that the service is not the accused to obtain in the way it is obtained." So all of this is somewhat complicated. Let's go with another example here. Let's consider you're a worker. You've gone to somebody's house. You're doing some, you're a plumber, say, and you've agreed that you are going to do a certain task, and that for that task you're going to be paid the sum of $500. You complete that task, and the homeowner has left the house at the point where you're completing the task, and you get out and you see that left by the door is $500 in cash, 5 $100 bills. And you think, we agreed that it would be $500. They've left me $500. Excellent. You pick up the money, you put it in your pocket, you write out a receipt, paid in full, and you leave it behind, and you exit the building. Now, unbeknownst to you, that $500 was actually for another member of the homeowner's family. That was not for you. And in fact, the homeowner has already called your company and made a payment over the phone. So you made a mistake in grabbing that money. You're not going to get convicted of the theft, assuming these facts are proven at trial, because you didn't mean to, to do this improperly. You thought you had a right to that money, that it was being left for you. That's sort of an example of what they're talking about here. So some courts have stated that fraudulently requires more than gross negligence, and the court in this case they cite has held that fraudulently required more than very incompetent or very careless. So different language here. They're basically saying, even if you are a real screw up, that's not the same thing as fraudulent. You might be acting in a real dumb way, but that's not the same necessarily as the criminal standard. To be said to have converted something, an accused must do more than simply use that thing. Conversion requires that the lawful owner of the property be deprived of the use and possession of the thing in question, and that the accused intended such deprivation. So let's give another example here. Let's say you are, you go to a big warehouse store that deals in hardware, and you get on one of their little carts that they use, like a motorized cart that they use for moving heavy objects, and you cruise down a laneway with it. You probably haven't stolen that cart. There's other offenses that they could charge you with, but you probably haven't stolen that cart because it's still around. You just shouldn't have driven it down the aisle. But let's say if instead of just driving it around, having some fun and leaving it there for the owner, let's say instead you will leave the cart aside. Let's say you go and you find some valuable item and you throw it in their trash. That would probably count as conversion, because now, assuming they don't find this thing, they can't use it for the things they meant to. So courts have held that an honest belief in abandonment can eliminate the intent to deprive and/or relate to the accused's color of right. Evidence of color of right is more appropriately viewed as evidence that prevents the Crown from proving mens rea than as evidence supporting an affirmative defense. With respect to theft, if the accused acted on a genuine misconception of fact or law, the defense of color of right is made out. And they cite to the Queen and DeMarco. The term color of right generally, although not exclusively, refers to a situation where there's an assertion of a proprietary or possessory right to the thing which is the subject matter of the alleged theft. One who is honestly asserting what he believes to be an honest claim cannot be said to act without color of right, even though it may be unfounded in law or in fact. The term color of right is also used to denote an honest belief in a state of facts which, if it actually existed, would at law justify or excuse the act done. The term, when used in the latter sense, is merely a particular application of the doctrine of mistake of fact. The existence of a color of right negatives fraud. There may be an absence of any fraudulent intention, however, notwithstanding the absence of a color of right to do the act in question. For example, the taking of another's property temporarily by way of prank. So that might negate the fraudulent element of things. So let's consider another color of right example. Let's say you are driving a really old classic car, and a lot of those really old classic cars had keys that maybe kind of were not the best and might be a little interchangeable. So you've left your car in the parking lot, and unbeknownst to you, somebody else has the exact same make, model, and color of car. And you get out, you go in their car, you don't check the plate, because who checks the license plate when you're getting into your own car? You try the key in the door, works just fine. You try the key in the ignition, works just fine. You drive home. And on the way home, you get pulled over by the police, who are super unhappy because they've determined that you have stolen this car. And in fact, the owner of the car is super unhappy. But here, the mistake is that you have an honest belief that this was your vehicle. And, there's various things that support that honest belief. So it would be I would say that somebody was not likely to get convicted in that scenario. Conduct is not fraudulent merely because it is unauthorized unless it is dishonest and morally wrong. In the Queen and Feely, the court said, in our judgment, a taking to which no moral obloquy can reasonably attach is not within the concept of stealing either at common law or under the Theft Act of 1968. Obloquy. Man, that's a word, isn't it? So you might be wondering, what the heck does that mean? It means sort of public condemnation. That is a 1973 decision, so I was going to say that there might be some defense to using that particular term if it was perhaps a 1793 decision. But in 1973, I don't know why we're still using words like obloquy. Come on, let's try to get our judgments a little more accessible to the public. I had to look that word up. I mean, I'm not trying to dunk on the public here. That's just an obnoxious word. Cool vocabulary, but not the time. Analysis and conclusion in relation to theft. The Crown submitted that Constable Senior should be convicted of count 1, the theft, if this court was satisfied that he kept the police money intended for Henry or for the wafer source or both. In each instance, the Crown submitted the money in question was the property of the police and was entrusted to him as part of his duties for the purpose of disbursement to specific people, and that did not occur. It is the view of this court that it is not that simple, and I think the court is right here. It is worth noting that Constable Senior never raised the notion of paying confidential human sources for information. The issue was raised by UC1 and Detective Sergeant Bedford. In other words, Constable Senior showed no interest in extracting such money from the police in order to have it for his own benefit. Also worth noting is that on July 16, 2018 and August 23, 2018, Constable Senior was given information on best practices for handling a confidential informant. However, there was no indication that Constable Senior was told what to do if the source accepted the money and then abandoned that money in his presence. It's also worth noting that the best practices information is coming from Undercover 1 here, UC1. That's the undercover cop who's pretending to be his partner, and whose goals are to get Constable Senior to screw up, to commit an offense. So the guy he's relying on to teach him how to do this job is actually trying to get him to screw up in ways that are criminal and that can get him into trouble. Wee bit of a problem, right? And it's not like UC1 is, acting like a corrupt cop here. He's acting like a cop on a mission to throw his partner under the bus, because that is in fact his mission. So the other thing is that we know is that the best practices are that constable, any constable doing this meeting should have somebody else there. It should always be 2 people, and that way they're checking each other's work. So there's no, it reduces the possibility of corruption, because anything you do, your partner can report on you. And Constable Senior was very much trying to make sure that UC1 would come with him to these things. Unfortunately, every time he does, UC1 suddenly flakes out. He's got somewhere to be. He can't make it. So Constable Senior was stuck in the position of having to go to these things himself because his partner was just never available. Again, all of that is specifically because they're trying to get him to screw up here. So with respect to the 2 payments to Henry, this court has concluded that Constable Senior knew that if Henry refused to sign the form as accepting the money, he would need to indicate refused on the form and return the money and form to the police. Constable Senior indicated as much to Henry during the meeting on August 25, 2018. However, it is not clear that Constable Senior knew what to do if Henry acknowledged receipt of the money, but then essentially abandoned the money. In relation to the first payment to Henry, the following facts are of note. UC1 provided the $1,000 in notebook to Constable Senior on August 23, 2018. UC1 advised him to arrange to pay Henry. UC1 had filled out the YRP 480 confidential human source payment form to compensate Henry. And I'm skipping ahead a little bit here, but Constable Senior stated, "But I don't want to be responsible for this cash." UC1 suggested that he lock it in his desk. The two then joked about what to do with the money. Constable Senior clearly was expressing concern for having the money in his care. We went over this a bit. He was saying, "I don't want this money. I shouldn't have this money. Somebody else take it. Why am I stuck with this money right now?" So on August 25th, they arranged to meet. He's meeting with Henry, who is in fact, he's the operator who's pretending to be a organized crime figure. He's the confidential human source, but he is actually an undercover police officer. So on the middle console, this is in the truck where everything is wired up for sound, so they've got recordings of this. On the middle console was the 1-page payment form. In the cup holder on the right side were a bunch of brown bills, $100 denominations. Constable Senior asked Henry to sign, print his name, and take the money. Constable Senior stated, "Brother, this is the way they work. They want it. They want it kind of like you give this information, just say thank you, appreciate it, here is compensation." Henry indicated that he was insulted and did not need the money. So not only does he not want it, but this is something he takes as a personal insult. Now keep in mind, Henry is really important to Constable Senior's life right now. Constable Senior is having all of these massive work successes. These emails are going out from his bosses to like everybody around him, talking about how great the work he's doing. How wonderful this is. It looks like Constable Senior's on, people are talking about him being on promotion track. And so insulting your confidential human source is not a great thing here, especially when it's somebody who's, your career's kind of tied to this guy at this point. Stating a G note is like fucking, it's not even a sneeze, man. I make that in minutes. You know how much coke and fent I bring into this country a month. They went back and forth between the two. Constable Senior explained to Henry that he could refuse. Ultimately, Henry agreed to sign. Henry took the money in his right hand and put it in his left shirt pocket. They exited the vehicle. Henry continued to express how he was insulted. So he is not happy with this. They go into the club. They have drinks. They have dances. This is an exotic dance club, basically. Henry took the money, put it on the table, and told Constable Senior to take it and do whatever you want with it. Constable Senior took it and put it back in Henry's left chest pocket. There were dancers present. Constable Senior told him to give it to the girls. Henry took the money out again and put it on the table. Henry said, "Do whatever you want with it." Constable Senior then took it with his right hand. Henry turned his head for a short time to scan his surroundings as there were people around, and Henry did not see where Constable Senior put the money. When he turned his head back, it was no longer on the table. So on August 27th, they say a little later on during breakfast, Constable Senior talked about what happened with Henry at the meeting. He stated that Henry expressed that this was not what he signed up for in regard to payment. Constable Senior reported that he told Henry he could refuse and he could take the money back, but that Henry eventually took it. And he drops off the form. The attached form indicated I, CHS 5599, acknowledged the receipt of the sum of $1,000 and was purported to be signed by Henry Wong and witnessed by Constable Senior. Nothing in the email or on the form indicated that Constable Senior ultimately ended up in possession of the cash or that Henry did not keep it. Henry signed the receipt, took the money, and had it in his possession for a period of time before putting it back on the table twice and telling Constable Senior to take it. It seems reasonable that Constable Senior would have believed that the owner of the money at that point was Henry, not the police. There's no other reasonable conclusion to draw. In fact, once Henry signs for it, it is his money. Like, if he goes and spends it on whatever, if he decides to buy $1,000 worth of gumballs, that's his money to do with. Henry is entitled at this point to do pretty much whatever he wants with that money. If he wants to throw it into a dumpster, cool. So it would not be reasonable to infer that Constable Senior intended to take or convert to his own use the money with the intent to deprive the police, given that it appeared that Henry had taken ownership of the money. In fact, if he's stealing from anyone here, it's that he's stealing from Henry, except Henry is saying, take the money. So how could it be theft from Henry? It would not be reasonable to infer that Constable Senior intended to take or convert to his own use the money with the intent to deprive Henry, given that Henry had physically taken the money and put it on the table, telling him to take it twice. The evidence is far from clear that Constable Senior knew that he had no lawful claim to the money at that time. This to me seems not like a criminal matter, but a police procedure matter. In terms of legal ownership, once Henry signs for the money, it's Henry's money. And then when he says, I don't want the money, and he gives it back to Constable Senior, the issues here are Constable Senior should not be taking money from a person he believes to be a confidential human source. And, there's probably procedures in the sense of he should return that to the police if this happens. Although I'm not sure if they actually have rules for this. I don't see it coming up that often where somebody signs for the money and then gives it back. That seems like a weird thing. But regardless, clearly police should not be taking money from people they think are drug dealers. I think that one we can all kind of agree on. So, but again, that's not really a criminal thing here. It's more, in this case, a thing of police practices. Is he violating the rules that bind him as a police officer? While it is true that the police had a special property or interest in the money, this court is unable to conclude that Constable Senior knew this at the time. The only conclusion that Constable Senior could have come to in these circumstances was that Henry had reluctantly accepted the money and was now the lawful owner. What they're talking about here is that because Henry is actually a police officer, it's still police money once Henry signs for it. Because Henry is not acting for himself. Henry, in this situation, is actually an undercover police officer, and he's not actually able to spend that money. That money is evidence. But if Henry was an actual criminal, then he could have spent it on, whatever, the gumballs example. So from the perspective of Constable Senior, Henry is a person who can take this money. From the perspective of knowing what we know after the fact, Henry is only accepting the money on behalf of the police because this is a whole massive undercover sting operation. Any evidence of Constable Senior's intent to deprive the police of this interest is lacking, because of course he doesn't know that he's under investigation at this point. They put a whole lot of effort into this being secret, and yeah. And if he knew that it was a police investigation, he wouldn't have done any of this. From Constable Senior's perspective, the $1,000 had already been transferred to Henry. He signed for the money, took possession of the money, and subsequently abandoned it in Constable Senior's presence. To suggest that Constable Senior must permanently consider the police's interest in the money in these circumstances is unsound. It is somewhat concerning to this court that Constable Senior did not tell UC1, so his partner, the whole story, specifically that Henry abandoned the money. However, this does not establish Constable Senior's intent beyond a reasonable doubt. Given the information that he had, this court is left in reasonable doubt as to Constable Senior's intent at the relevant time. And so what that means, he's going to be acquitted with respect to that $1,000. The second interaction with Henry for payment is a bit more troubling, as this court accepts that Constable Senior did not explicitly offer the money to Henry. In relation to the second payment to Henry, the following facts are of note, and I'm going to skip over a bunch of them here. So Henry was presented with the money receipt form, which he signed. There was money in the cup holder, brown bills. Henry never touched the money. Constable Senior never asked Henry to take the money. As Henry was exiting the vehicle, he saw Constable Senior grab the money with his right hand. He did not see where Constable Senior put the money. Henry agreed that he left the money behind on purpose. Not accidentally, he meant to leave the money because, of course, he's trying to tempt Constable Senior. He had no idea what Constable Senior did with the money. He never saw the money again. They exited the vehicle. There was no further discussion of the money. On September 12, 2018, Constable Senior emailed the signed payment form to Detective Sergeant Bedford. Nothing in the email or the form conveyed that Henry did not take the cash. Again, Henry signed the form acknowledging receipt of the money, thereby transferring ownership of the money from the police to Henry, at least in the mind of Constable Senior. The money was left in plain view in the cup holder for Henry to take. While he signed the form, Henry did not take the money. but rather abandon the money. And again, Henry has indicated that he is insulted by this. He doesn't want the money. Again, the evidence is far from clear that Constable Senior knew that he had no lawful claim to the money, given Henry's abandonment of it. It is the view of this court that the Crown has failed to prove that Constable Senior intended to deprive another. As for the $300 earmarked for the Sherry Wafer information source, David Broadhead, there is frankly no evidence of what happened to this money after it was given to Constable Senior, other than the comments made by Constable Senior to UC1. However, it is clear that Constable Senior had his friend forge David Broadhead's signature on the payment receipt. So this one is going to be more complicated. Following facts are of note, and I'm going to cover sort of some of these, but not all of them. I did go through all of this in more detail in previous videos. So on Tuesday, August 14th, 2018, Constable Senior advised UC1 that his wife had learned about his extramarital affair with a woman named Sherry Wafer. Constable Senior then provided a great deal of information to UC1 about Sherry Wafer and their relationship, including her background, how they met at the gym months previously, problems she had been having with her ex, and that her mother was a drug dealer who moved drugs across the GTA. Constable Senior told him that he wanted to call CAS to fuck over Miss Wafer. Constable Senior also expressed that he wanted to do an intelligence report on Ms. Wafer. UC1 offered to help Constable Senior document the information. So, a lot going on in that. I kind of feel bad for Miss Wafer because I'm sure she didn't want her business being broadcast in, court things and media across the country. It's also kind of scary that, because she's dating with this cop and it's ended badly, apparently. This cop is using his police aspects to go after her. That's kind of worrying. Hopefully that's not a thing that, other cops are doing. Yeah, so it was clear from the discussion that the source of the wafer information was Constable Senior, and that Constable Senior did not want his information known. So he's providing information about these things to the police. UC1 explained to Constable Senior that the intelligence report would not be disclosed, so it's not going to be handed over to defense lawyers, it's not going to go over to the court. And with the encouragement of UC1, he moved forward. So he's going ahead with the report. It's also clear that Constable Senior did not want to be known as the source of the information, and UC1 offered to assist with anonymity. So his buddy's helping him out here. Let's see how far his buddy's help gets him, So on August 22nd, 2018, Constable Senior replied to Detective Sergeant Bedford, "The latest information I submitted was from a new source and was a one-time exchange. I will complete the sheets and submit them back to you ASAP." Little later in the morning, Constable Senior texted UC1 and said, "Sorry for bothering you on your day off, but Bedford wants YRP 256 and 257 filled out, so those are forms. Not sure how to fill out my information. Call me." At 2:05 p.m., Detective Sergeant Bedford responded to Constable Senior's email and stated, "I'm sorting out payments for a number of files and want to ensure your CHS gets paid before I go away. Please ensure that I get these forms before 1600 today, as I require them to process payment." Again, Constable Senior hasn't said that he wants the payment. They're pushing these payments through because they're trying to ensnare Constable Senior, is what it seems like. It seems weird that they would insist on paying people who don't want to be paid. I mean, just as a taxpayer, if you've got a source that doesn't want to get paid, don't pay them. Use that money for other things. We pay enough taxes for you to be forcing money on random, mostly criminals here. So they don't want the money. Don't give them the money. Just, maybe a little bit of a suggestion for police forces. But I don't think that's, I don't know for certain here, but I suspect that's not the common practice. I suspect that they were trying to push the money through to make sure to create problems for Constable Senior with respect to the money. But again, can't say for certain one way or the other. And I don't think anyone is going to get in touch with me and fill me in on the police confidential practices for how they deal with confidential human sources. So at 3:57 p.m., Detective Sergeant Bedford responded to Constable Senior. "You didn't name the CHS, so the source on the 257. Can you fill it in and send it back before you go? The rest is sufficient for payment." On August 23rd, 2018, Detective Sergeant Bedford emailed Constable Senior and UC1 to say, among other things, "I'm still awaiting the name of your one-time source on the police 257 you sent yesterday. Please ensure I get that by day's end today. So they're putting time pressure on him as well. And meanwhile, he's trying to get information from UC1, and UC1 is blowing him off. So they're putting this time pressure on him because there's only so long that UC1 can blow him off, but they want to make sure that Constable Senior, who doesn't know what he's doing, he's relying on UC1 for information, they want to make sure that he is unable to get that sort of fill-in information here. So in the early afternoon, Constable Senior and UC1 exchanged text messages in which Constable Senior asked, "What do I put for the 526 informant info? Not using my name." So they meet back at 5 Corps. He asks about the name. UC1 says they should talk outside. They go to the lunchroom. UC1 basically is unhelpful here. He basically says, if you want to come clean, you should use your own name. Constable Senior says, "No way, are you crazy?" Now he's telling him to use his own name, but of course before he was telling him to do it anonymously. So they're sort of brainstorming up a name. They come up with David Broadhead eventually, or at least Constable Senior comes up with David Broadhead. So UC1 said, "So what are we doing with the effing cash?" To which Constable Senior responded, "I don't know. You tell me, bro." Laughs. Constable Senior then stated he would get somebody to sign off. "I'll donate to charity." So he's in a tough bind because he's basically filled out these forms that he didn't want to have his name on, and once he's submitted them, now he's got to put a name on them. UC1 had to know that this was what was going to happen here. On that same day, September 10th, 2018, Constable Senior attended the home of his friend, Fabian Wills. Mr. Wills left his house and got into Constable Senior's Ford F-150, which of course is bugged. So this was kind of a terrible decision here. Constable Senior and Mr. Wills had a conversation in which Constable Senior explained that he had a bunch of confidential sources, CIs and shit, and "I need you to forge somebody's signature." Constable Senior handed Mr. Wills a confidential human source payment form and told him to print D. Broadhead and then place that signature on the form. There was no indication on the recording that Constable Senior provided the money to Mr. Wills. In fact, it is not clear what happened to the money. So we don't actually know who ends up with this money. Probably Constable Senior, but who knows? So on September 12, 2018, Constable Senior emailed Detective Sergeant Bedford the scanned receipt Fabian Wills had forged David Broadhead's signature on. The YRP 480C stated that CHS, one-time source, acknowledged the receipt of the sum of $300. $350 was crossed out and initialed by Richard Senior. Dated September 10th, 2018, purported to be signed by D. Broadhead and witnessed by Constable Senior and UC1. On September 12, 2018, Constable Senior told UC1 that he gave the $300 to Homeboy's side piece and had her sign for it. There's no question that Constable Senior had Fabian Wills sign the payment form by forging David Broadhead's signature. Constable Senior then fabricated a story to UC1 about who signed the form and where he left the money. If Constable Senior had actually been in a position to leave the money with David Broadhead or his side piece, he would have had no reason to ask his friend Fabian Wills to forge Broadhead's signature minutes earlier. Further, it does not make sense that Constable Senior would bring an intelligence report falsely attributed to David Broadhead to Broadhead's or his girlfriend's attention. Because of course you wouldn't want to do that, right? Hey, by the way, and we've heard that Mr. Broadhead, and this is just we've heard, we don't know for certain, but what Constable Senior seems to believe and is telling people is that Mr. Broadhead is involved in some sort of criminal activity. I don't know Mr. Broadhead, I don't know his circumstances, but if he is involved in criminal activity, providing information to the police tends to be a big deal. It tends to be something that other criminals do not appreciate in the slightest. So putting somebody else's name in forms like this is kind of a big deal from the perspective of the guy whose name went on the form. I'm sure he also would not be thrilled to not get the $300. So it is the view of this court that the only reasonable inference to draw is that Constable Senior kept the money for himself, knowing that he had no lawful claim to it. Constable Senior took the $300 intended for David Broadhead that belonged to the police. He took that money fraudulently and without color of right in order to cover up the fact that he had falsely attributed the information on the intelligence report to David Broadhead. Given Constable Senior's behavior and comments, he most certainly knew that he had no right to that money. When Constable Senior took the money, he meant to deprive the police of their interest in it. Upon accepting the money, he stated that he would get someone else to sign off, which was exactly what he did, and then dispose of the cash. Therefore, Constable Senior is found guilty of the offense of theft under $5,000, but only as it relates to the $300 payment to the Sherry Wafer source. So, with respect to the first $1,000 to Henry Wong, didn't do anything criminal. With respect to the second $1,000, again, not convicted with respect to that, or not guilty with respect to that. But for the $300 on the Sherry Wafer source, they've said that makes out the offense of the theft under $5,000. So as you can see, this is some fairly complicated matters. This is one of those unusual cases where the law gets really difficult. And difficult law is often interesting from the perspective of a lawyer. This is the kind of stuff that is really fun. Less fun if you're the one paying the lawyer for it and, on the hook. But it's a really good case to look at just to pick apart and see the law that's going on. Have a look under the hood of how the courts operate. Now, we're about an hour deep. It's been quite a bit of heavy law here, so I think I'm going to call it for this next iteration, and there'll be continuation. We'll go into the other counts here. But thank you for watching. If you've enjoyed this, please like this video. Please share it with your friends. Please subscribe to see more content. I know these long ones are not for everyone, but I like mixing up the long videos with the short videos because sometimes you just really need to get in and really engage with a case and pick it apart. And this is the sort of thing I really like doing. I really enjoy this kind of digging into interesting cases like this one. So I also want to thank my Patreon supporters at the $50 level: Jason Elliott, Demo, Canada's National Farms Association, North Central Process Service, Kyle Martin, Jean-Guy Toussaint, Ivo Nedev, the CCFR, BCAMF.org, Andrew Schaefer, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Marc-Olivier Damour. And at the $20 level, Matt Ward, Mark Whittington, Dale Nesbitt, Cameron Johnson, Andrew Elsich, and Adam Meester. I also want to thank all of you at the $10 level who will be in the crawl immediately following. Thank you for watching. This case is wild. As I've said before, I started looking at this case kind of figuring that this would be one of those cases where you're just like, yeah, this bad cop is going down, and isn't that fantastic? Something we can all just cheer about, something that is kind of an unqualified win for society. Man, is it more complicated than that, and it's going to continue to be more complicated than that. So I hope you'll stick with me for the next iteration. Once again, thank you for watching, and I hope I've armed you with knowledge.